Hi there, it's Wendy Hernandez. I'm the creator of Command the Courtroom. And today I want to talk to you a little bit about how child custody hearings work. A lot of times I get questions by people representing themselves in court, and they don't know what to expect when they set foot in the courtroom. They don't know who the judge is going to call to talk first, when they call their witnesses, when they cross-examine. So today, I'm going to give you a little bit of a roadmap so you know what you can expect if you're going into court for a trial, an evidentiary hearing, or a temporary orders hearing. So normally when you get to a trial, regardless of whether it's a child custody trial or a divorce trial, the person who filed the action that's pending gets to present their case first. So if the case is a brand new case, the person who filed their action first would be the plaintiff or the petitioner. And the person who got served with the action would be the defendant or the respondent, and they would present their case second. So when you go into court for a trial and say you're trying to modify child custody or parenting time, for example, if you filed the case, then the judge would expect you to step up to the plate first. In your jurisdiction, if a judge expects you to make opening statements, then you would have to make your opening statement first. And if you're the respondent or the defendant, then you would get to make your opening statement next or second. After opening statements are made, then the plaintiff or the petitioner has to present their case in chief. What that means is that they have to call all of the witnesses who are going to testify on their behalf, including themselves if they're representing themselves and they want to talk about their case. So it's really important to think about the order in which you call your witnesses and to be mindful about how much time you have. In these types of cases, usually there's limited time. You don't have days on end to present the cases. So really it makes sense to choose the best witnesses to testify on your behalf. And hopefully you've done your homework and you've prepared the witnesses, you've practiced with them, you've hit on the points that are most important and that are relevant to your case. So if you're the plaintiff and you're calling yourself as the first witness, then you would get up on the stand and you would talk to the court about what it is that you want and all of the areas that are in dispute. Once you have completed your testimony, or once you have called your other witnesses, then the other side gets a crack at asking questions of you, and this is called cross-examination. During cross-examination, the other side is probably going to try to ask you leading questions if they know what they're doing. They're going to try to box you into an answer and make you say yes or no without much explanation. So do the best you can with this. There's some judges who are really strict about saying you can only answer yes or no, and other judges let you have a little bit of leeway in explaining things. But kind of think about the areas where the other side might try to expose the weaknesses in your case or show that you were giving inconsistent or you were providing inconsistent statements. This is called cross-examination. After cross-examination, if you're on the stand, for example, then you're going to have the chance to talk again, and this is called redirect examination. During redirect examination, you get to clarify the areas that you think need clarifying after the cross-examination. So say the other side asked you a question, you only were able to answer yes or no, but you wanted to say more. If the judge didn't let you, then during redirect, you get to do that. So if you're not the witness on the stand during redirect, say you've called another witness and you've already done your direct examination of that person, the other side will get to cross-examine that person, and then you get your chance to rehabilitate that person during redirect examination. So you go through this process for each of your witnesses during your case in chief. You call the witness, you ask them the questions you want to ask them, and you admit the evidence that you want to admit through each of these witnesses. The other side gets to cross-examine the witness, and then you get to redirect examination of the witness and rehabilitate them. Once you've presented your case, then you tell the judge, I rest my case. And the next thing that happens is the other side then gets to go through the same process with their case. They get to call their witnesses. If you are the respondent, then now it's your time to tell your story, your side of the story. If you're calling yourself as a witness, and you get up on the stand and you testify. And once you've said what you have to say, then the petitioner or the plaintiff will get a chance to cross-examine you. Once the petitioner or plaintiff has cross-examined you, then you get a chance to testify again during redirect examination and rehabilitate yourself in any areas where you think you got hurt by cross-examination. If you're the respondent, in addition to yourself, if you have anybody else you want to testify, any other witnesses, then you call those witnesses during your case in chief. And you ask them questions, and again, this is called direct examination. Once you're done examining those witnesses, the other side gets to ask them questions during cross-examination. And then it goes back to you. You get to rehabilitate your witnesses during redirect examination. So once all of the witnesses have testified and the evidence is in, then both sides rest. Depending on your jurisdiction, then the judge may or may not ask you to do closing arguments. So for the closing arguments, the person who filed the action first, the current action first, the petitioner or the plaintiff, would give their closing argument first. And the person who was responding to the action that was filed would give their closing argument second. And then normally the petitioner gets the final say. And they get to do kind of a mini brief closing argument in response to the respondent's closing argument. So I know it seems a little bit confusing and overwhelming, but the basic pattern, whether you're the plaintiff or the respondent, is the same in terms of actually presenting evidence during the trial. First, you present your case in chief, which is your testimony or the testimony of your witnesses and all the evidence that you want to admit, the physical evidence that you want to admit through those witnesses. So after you are done with direct examination with each witness, the other side gets to cross-examine that witness or cross-examine you if you're the witness. Once the cross-examination is complete, then you get to talk again, and you get to try to fix any areas where you think that you got hurt by the other side during cross-examination. This is called redirect examination. So this is the flow, whether you're the plaintiff or the respondent. There's sometimes an opening statement at the beginning and a closing argument at the end. So that's the basic flow of custody trials, evidentiary hearings, and temporary orders hearings. I want you to keep in mind that, things may vary a little bit depending on state and local rules. So be sure and do your homework and brush up on your state and local rules. Certain judges have preferences about how things go in their courtroom. So if there's a website that you can go to where a judge lists rules for the courtroom, take a look at it. If you have the chance to go and see your judge in action before your trial or your hearing, I would highly recommend you do that so you know what to expect of your judge and you know what to do and what not to do. So I hope that this is giving you kind of an idea of what you're looking for or what you should be looking to do when you go into the courtroom. I'm here to help you keep the faith and keep moving forward. You can do this on your own, and I'm on your side when it matters most. If you want more of Command the Courtroom, check us out on our YouTube channel or go to commandthecourtroom.com.